You're charged with the offense of felon in possession of a firearm. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Right out of the gate, this is serious. In Texas, felon in possession of a firearm isn't a slap on the wrist charge. It's a third-degree felony carrying real prison time. The judge is laying the groundwork here. This isn't just paperwork, this is a potential decade behind bars. And notice how calm Mr. Taylor sounds. Do you think he fully grasps what 2 to 10 years actually means?
2022 CR 6828, State of Texas versus Alonzo Taylor. Could I have parties announced for the record for the state?
Danny Westmore, the State of Texas.
For the defense?
Greg Desmarais.
And are you Mr. Taylor?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Is there an application?
There is an application, Your Honor.
And is that application for deferred and regular?
It is, Judge.
All right. Mr. Taylor, did you review a document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you sign it and did you understand it?
Yes, ma'am.
Showing you the true bill of indictment. Could everyone please whisper? Showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am. Yes, Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, go.
Mr. Taylor, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of felon in possession of a firearm? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I do.
Mr. Taylor, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $1,500 fine and the state will remain silent on your application. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
I did, Judge.
State?
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states Exhibit 1 in all attachments.
No objections, Your Honor.
All right, state, you may be excused.
Judge, there were also 2 TICs that were supposed to be written in there. I apologize.
Oh, no problem.
No objections.
All right, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Ms. Ferguson, I need a PSI report.
Yep.
Yes.
May 10th work?
This is where it gets interesting. They're applying for deferred adjudication, which basically means if he follows every rule perfectly, he could avoid a final conviction on his record. But here's the catch: deferred is a privilege, not a guarantee. Point one, slip one violation, and that full 10-year exposure comes roaring back. Would you risk it?
I only say that because I have another court date, but I can make it work. So whatever.
Well, let's put it on May 10th and see if it's ready. The PSI report may not be ready. That's the only issue.
Yes, ma'am. And Judge, if I may, the state has agreed to a $20,000 bond on this case. He was didn't have a bond set. He'd missed his court date, and that was that. And picked up these new cases. But I'm asking if the court would agree to a $20,000 bond. He's been in jail for 2 months. Obviously, our application for probation. I want to get him out there. I want to get him a job. I want to get him working.
All right. So with regards to that, the new cases that are being dismissed were taken in consideration.
Yes.
So I would need to know what the new cases are and what the offense dates are. Are you going to be here tomorrow? You think you're going to?
I won't, Judge.
What if you're on the jury?
Well, I don't know. They're calling. I may be removed from the panel by now.
Well, I tell you what we can do is we can do it by Zoom, because I know you have to go. If you're available to do it by Zoom, we can take care of this by Zoom.
If the bond is
They want a bond for
Yeah, that's fine.
because I only need a few things that I don't have, and I know you're in a rush. Like I need to know no problem. I just need to know the offense dates for those charges. And the state may be able to get that to me, and I'll be able to make a decision on your agreement or not.
Yes, ma'am. We'll take care of it.
Okay.
Well, we can give you the information if you want, Judge.
Yes, if you all will write it down and give me that information,
Yes, ma'am.
and then go ahead and do your jury duty.
Okay, thank you.
Okay.
And if we get a break, I'll come back up here.
Sure.
Okay.
Okay.
Oh, wait, we have the offense dates. Right?
The alternate state judge for those two cases that were taken into consideration are February 10th, 2023. And they happened at the same time.
The same time as this.
No. This is felon in possession and an evading arrest in a vehicle. Happened on the February 10th, 2023 case.
Mhm.
And then he was out on bond on the felon in possession case. That happened on April 2nd, 2022.
All right. So what bond are you all asking for?
I believe he was asking for bonds on the indicted case that he just pled to.
Correct.
And are you all in agreement on a bond?
Well, the state recommends it was set at 20,000 when it was initially, and I believe I went up to 20,000, and that's what the bonds are set on the two new cases also, Your Honor.
Yes, ma'am. So we had agreed earlier to a $20,000 bond. For Jason?
That was, I'm sorry, that's correct.
Yeah, it was 10 and then you moved
That's what
it to-
the recommendation was, and that's what I believe stated.
All right. So Mr. Taylor, you're under oath. It appears that in the police report that I have that there may have been some marijuana. So
In the
do
report that was
you
just
use
played.
marijuana?
Yes, ma'am, a little bit.
All right. What does that mean? How often are you smoking marijuana?
Probably like once or 2 times a week.
Okay. Anything else?
No, ma'am. Well, I drink a little bit this year.
Who do you live with?
I live with my mom.
Does she want you there?
Yes, ma'am. She's in the car right now.
All right. Where's his mom?
She's in the back with the master.
Okay. Who else lives there? Any minors? Any children?
Yes. My brothers and my sister.
And how old are they approximately?
One's 17, and another one's like 24.
Anyone younger than 17 live in the house?
Yes, my little brother, 10 years old.
Your Honor, do you want me to bring?
Judge, sorry, just to,
Yes.
if it's on the
Yes.
record, I see that the mother.
Yes, let's bring Mom up.
Yes, ma'am.
Taylor, on this side, please.
Or everyone else guessing who lives in your house.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. State your name for the record.
Tracy Tejeda.
Tracy.
Tejeda.
All right. How many children are living in the home?
So I have my 4.
Okay, so what are their ages?
10, 9, 13, and 17.
Okay. And is it just you, the children who live there?
Yeah, me, my daughter. My daughter's right here is with me too. She's 25, and then just the kids, and then Alonzo.
All right. Do you want Alonzo in the home?
Yeah.
All right. I'm going to set his bond, but I'm going to put him on GPS.
I was gonna ask. Thank you.
I'm sorry.
I had originally asked him if we could.
All right. So it's going to be GPS. And the only time he's going to be allowed to leave the home is if he has employment. So it's going to be full house arrest. And if he gets employment, then just let the court know and I'll consider that.
Thank you, Judge.
So I'll set his bond at $15,000 since I'm putting him on GPS.
Yes, you are.
I'll ask that the fees are waived, or deferred.
And this is the pivot moment. He's under oath. The judge already has the police report, and instead of minimizing or clarifying, he casually admits to using marijuana. In a bond hearing. While asking for freedom, that answer just changed the temperature in the room. Remember, bond decisions are about risk, and now the judge is thinking risk to who?
Thank you, Judge.
And thank you so much for coming
Thank you,
in.
ma'am.
I do have a question.
Yes.
Go ahead.
For treatment for Alonzo outside of the facility, because he is considered disability. So I already have somewhere for him to go so he can start to get from Central Health Services.
So you're saying while he's out on bond, if he can
Yeah.
go to this facility?
Mhm.
All right. And I'll put in there, he's allowed to attend all medical appointments. And if there's an issue with GPS where they say he's not allowed to go someplace and it's for medical, just let your attorney know, or either you can come in court. We're here from 9 to 5, Monday through Friday, and you can come in and let us know if there's an issue.
Okay.
All right. Is there anything else he needs?
Well, just, some anger management classes, some counseling, stuff like
Okay.
that is something that would be really beneficial for him.
All right. Well, that's something, if I grant his application, that's something I'll take care on that end.
Yeah.
But I'm going to ask if you will be back here on May 10th as well. Ms. Ferguson, can you make sure they get a reset form for May 10th? If you could be here as well, because then I'll delve into more about what he may need if I grant his application. Okay.
And for the
Thank
court's
you.
info, we definitely are going to have his mom here
Okay.
for court that day.
All right.
Thank you.
Thank you.
Thank you. All right. Mr. Taylor,
Come on up.
I'm going to tell you, it is rare. Sometimes people show up to court, their parents don't come. So I'm going to set your bond at $15,000. You're going to be living at your mom's house. How old are you?
I'm 19.
All right, you're 19. That's an adult. That's why you're in adult court. But as far as living at your mom's house, and your mom's house, you are not an adult. You're a child. And let me tell you why. Because that's your mom's house. That's not your house. So if she wants you to wash dishes, you need to wash dishes. Do you understand?
Yes, Your Honor.
Now, on full GPS, if there's a barbecue outside and somebody wants you to come out and work the grill, that GPS is going to go off that you're violating your GPS zone. So you can't go outside in the yard to work the grill. If somebody wants to give you a barbecue plate, you can't be sticking your hand out the window to get it. You are confined in your home. You understand?
Yes, Your Honor.
If you violate this GPS, that will tell me something about whether or not you can follow the court's rules and whether or not I should place you on deferred or regular probation. You understand?
Yes, Your Honor.
All right. And I'm going to order that he do UAs as well.
Yes, Your Honor.
All right. Is there anything else?
Nothing, Judge.
All right. Could I get a B page on Mr. Taylor?
Thank you, Judge.
All right. And then that's the reset form. Have your client sign it and
Yes.
then enjoy your jury selection.
Open.
That's going to go well.
Thank you, Judge.
You're welcome.
The judge calling the mother up to testify. That's strategic. This isn't just about where he sleeps, it's about supervision, structure, accountability. When minors are in the home, the court has to consider safety. And here's the unspoken question: is this household strong enough to control a 19-year-old facing a felon? Boom, bond granted but with strings attached. GPS house arrest is essentially digital confinement. You step outside your zone alert, you test dirty violation, and violations don't just risk bond, they risk deferred adjudication altogether. This is the judge saying, I'll give you a chance, but I'm watching. This is the viral moment. Judge Stephanie Boyd isn't just sentencing, she's parenting from the bench. Legally he's an adult, practically he's still dependent, and this speech isn't just for him, it's for every young defendant watching. Freedom in the legal system comes with responsibility. The real question now is, will he follow the rules, or will we see him back in that chair?